So I'm going to read this amended one, and you can follow through. The bold print on the amended one is the amendments. Some of it's in there. Whereas Title 13 of the Millington Municipal Code establishes rules regarding property maintenance, and whereas Tennessee Code Annotated 6-54-113 grants municipalities the right to require owners to keep their property free of growth of trees, vines, grass, underbrush, flowers, plants, or any landscaping material and/or the accumulation of debris, trash, litter, or garbage, or any combination of the preceding elements that would endanger the health, safety, or welfare of other citizens, or encourage the infestation of insects, reptiles, rats, or other harmful animals, and whereas the Board of Mayor and Aldermen of the City of Millington wishes to exercise its rights granted under Tennessee Code Annotated 6-54-113 and to set guidelines for enforcement, and whereas the Board of Mayor and Aldermen desires to require lessees of real property to keep their property free of excessive growth of trees, vines, grass, underbrush, flowers, plants, or any landscaping material, and/or the accumulation of debris, trash, litter, or garbage, or any combination of the preceding elements that would endanger the health, safety, or welfare of other citizens, or encourage the infestation of insects, reptiles, rats, and other harmful animals. Now therefore be it ordained by the Board of Mayor and Aldermen of the City of Millington, Tennessee as follows. Section 1. Sections 13-105 and 13-106 of the Millington Municipal Code are deleted in their entirety and replaced by the following new sections. 13-105, overgrown and dirty lots. Number 1, prohibition pursuant to the authority granted to municipalities under Tennessee Code Annotated 6-54-113 and as provided in Section 301 of the 2006 International Property Maintenance Code as adopted by the city. It shall be unlawful for any owner of record of real property to create, maintain, or permit to be created or maintained on such property the growth of trees, vines, grass, underbrush, flowers, plants, or any landscaping material, and/or the accumulations of debris, trash, litter, or garbage, or any combination of the preceding elements so as to endanger the health, safety, or welfare of other citizens, or to encourage the infestation of insects, reptiles, rats, and other harmful animals. For purpose of this prohibition, grass of any kind, including monkey or mondo grass, that exceeds 10 inches in height on occupied property and that exceeds 18 inches in height on unoccupied property, whether residential or commercial, shall be deemed to violate this section. Number 2, designation of public officer or department. The city's Board of Mayor and Aldermen shall designate an appropriate department or person to enforce the provisions of this section 13-105. Unless otherwise designated, this section shall be enforced by the city's Office of Codes Enforcement under the supervision of the Director of Economic Development and Planning. Number 3, notice to property owner. It shall be the duty of the department or person designated by the Board of Mayor and Aldermen to enforce this section to serve notice upon the owner of record in violation of subsection 1 above, a written notice in plain language to remedy the condition within 10 days, provided, however, that if the owner of record is a carrier engaged in the transportation of property or is a utility transmitting communications, electricity, gas, liquids, steam, sewage, or other materials, the notice period shall be 20 days, excluding Saturdays, Sundays, and legal holidays. The notice shall be sent by registered or certified United States mail, addressed to the last known address of the owner of record, or hand-delivered with the deliverer obtaining the owner's signature confirming receipt of the notice. The notice shall state that the owner of the property is entitled to a hearing before the city's Director of Economic Development and Planning and shall, at the minimum, contain the following additional information. A brief statement that the owner is in violation of 13-105 of the Millington Municipal Code, which has been enacted under the authority, and that if the owner does not clean up the property within the time allotted, the property of such owner may be cleaned up by the city or its agent at the expense of the owner, and a lien placed against the property to secure the cost of cleanup. Such notice shall also state that in addition to the placing of the lien, the city may file suit in a court of competent jurisdiction to recover its cost of cleanup, and also cite the offender to city court as set out in subsection 9 below. C, the person, office, address, and telephone number of the department or person giving the notice. D, the cost estimate of remedying the noted condition which shall be in conformity with the standards of cost in the city. And E, the name, office, address, and telephone number of the city's Director of Economic Development and Planning, wherein the notified party may return a copy of the notice and indicate the desire for a hearing. Number 4, cleanup at property owner's expense. If the property owner of record fails or refuses to remedy the condition, or to request a hearing before the Director of Economic Development and Planning within 10 days after receiving the notice, 20 days as described above if the owner is a carrier engaged in the transportation of property or is a utility transmitting communications, electricity, gas, liquid, steam, sewage, or other materials, the department or person designated to enforce the provisions of this section shall immediately cause the condition to be remedied or removed at a cost in conformity with reasonable standards in the city of Millington, and the cost thereof shall be assessed against the owner of the property. The city may collect the cost assessed against the owner through an action for debt filed in any court of competent jurisdiction. The city may bring one action for debt against more than one or all of the owners of properties against whom such costs have been assessed, and the fact that multiple owners have been joined in one action shall not be considered by the court as a misjoinder of parties. Upon the filing of the notice with the Office of the Register of Deeds in Shelby County, the cost shall be a lien on the property in favor of the city, second only to the liens of the state, county, and municipality for taxes, any lien of the city for special assessments, and any valid lien, right, or interest in